Welcome to this webinar presented by Wrays regarding protecting your IP in the MedTech space. So my name is Bindhu Holavanahalli. I'm a lawyer here at Wrays, and I'm joined by my colleague, Dr. Phil Burns, who's a patent attorney. And we'll talk about a few hot topics in this area and a few things to look out for. So I guess to provide a general overview on what we're going to be discussing today, firstly, we'll talk about patent protection for MedTech inventions, what you can and can't patent in this field, and then what your options can be if you are not able to get a patent. Then I'll pass it on to Phil, who will talk about a couple of hot topics in the MedTech space, including the patentability of inventions that incorporate AI, as well as pivoting your technology from one space to another, which is obviously a consideration that many companies are sort of taking into account at this moment, given the current pandemic. Phil will also talk a little bit about IP ownership issues that arise in the MedTech space, particularly in a multidisciplinary area like this, where you've got a lot of collaborators. And then finally, I'll talk a little bit about how we can avoid disputes in this space by taking action early on. So I guess to get us started off, why should you get a patent? Why is it important? The first thing I think that springs to most people's minds is the enforcement aspect. The fact that you can stop third parties from exploiting your invention if you've got a granted patent, which is obviously a very valuable right to have. The second sort of advantage of having a patent is that a patent, whether it's pending or granted, can be a very valuable asset from a fundraising and investor perspective. This is particularly important as well in the software space or startup space, where even having a pending application on foot gives investors the signal that you're serious and you've got IP that is valuable and therefore encourages investment. And then further, both pending and granted patents are really effective deterrents. Third parties that are looking at public patent registers are able to see what your invention is and what the scope of your rights are, and therefore it serves as a deterrent effect, hopefully, to prevent third parties from encroaching into your space. So, what is it that you can patent? Well, in this space, in the MedTech field, I guess you've got the kind of physical device, the sort of traditional technology, and this is generally patentable provided that it's novel and inventive over the prior art. So and if it's new and inventive over what's already out there, a physical device will generally be patentable. But there are also a lot of software-based inventions in this space, and that's where there is a little bit more of a grey area as to what can be patented and what can't be. Phil's going to discuss this sort of line between what is patentable and what's not with respect to software in more detail when he's talking about artificial intelligence. But as a general rule, schemes and business methods that are facilitated by software, those sorts of things that are generally considered ideas or methods that are helped along by software are not generally patentable, whereas software that has a technical effect, something that presents a technical solution to a technical problem, can be patentable. And what is and what is not patentable in the software space is dependent on the jurisdiction. The US is generally speaking a little bit more generous, with the EU being a bit more restrictive in allowing software inventions, and Australia falls somewhere in between, but it is tending towards the EU approach. But Phil will discuss this distinction in a little bit more detail shortly. Other sorts of inventions that might fall within a grey area of patentability include method of treatment and medical procedure type inventions. So I guess from a pharmaceutical perspective, treatment regimes where you're using a known pharmaceutical compound to treat a new disease are generally patentable in Australia and in the US. They're also patentable in the EU, provided you use a specific claim or drafting format, whereas medical procedures such as surgeries that involve the use of a particular piece of physical technology, a device, fall in a little bit more of a grey area, and there's currently a bit of a question in Australia as to whether that's patentable or not. All of this is to say, the question of whether something is patentable or not is quite complex, and the best thing to do is to talk to your patent attorney about your technology and about your innovation, and they'll be able to advise you on which side of the line your innovation or technology is likely to fall. And remember, there are a lot of drafting techniques that patent attorneys can use to help frame the scope of your invention in a patentable way. So always talk to your patent attorney first. All is not lost if you can't get a patent for your invention. There are other ways in which you can protect your technology and your designs. The first approach is trade secrets. You know, everyone knows of KFC's herbs and spices. They've been protected for many, many years. One of the advantages to trade secrets is its unlimited length, whereas patents only give you protection for about 20 years. You've got to be really, really careful about the way in which you disclose your invention. Make sure you've got NDAs on foot for anyone that you discuss your invention with. And also, trade secrets are not going to be very appropriate where you've got a reverse engineering problem. So if once you put your product on the market, if someone can work out what you're doing from reverse engineering your product or device, then trade secrets are probably not the best way of protecting your technology. Another avenue is copyright protection. It's particularly relevant with respect to software because the source code itself is protected as a literary work under copyright. But what you've got to be aware of in copyright law is that it protects the expression and not the idea. So if someone, for example, were to slavishly copy parts of your source code, then copyright is going to provide you some protection with respect to that. But if someone is able to develop a piece of software that functions the same way as yours, but without using the same source code, then copyright isn't going to help you out there. Designs are also a good avenue for protection, particularly if you've got a device, a product that has a distinctive shape or configuration. So it's all about how it looks rather than how it functions. So it might be an appropriate avenue where, for example, the actual function of your device is not novel or inventive, so couldn't, get patent for it. But the shape and configuration or the look and feel of the product is distinctive, and designs may be the approach for protection there. In Australia, designs protection usually lasts 10 years, but the length of protection is different in different countries. And the other thing to be aware of with designs is, like patents, self-publication can destroy the novelty of your design application. So what you've got to do is make sure you file your designs before you release your product or launch it or disclose it in any way. So there are a few options you have if patent protection is not available to you. So on that note, I'll pass it on to Phil, who'll talk a little bit about AI as a hot topic in MedTech.
Thanks, Bindhu. So in medical devices in the last 5 to 10 years, artificial intelligence and machine learning has certainly been coming more to the fore, particularly in when you have advances in computer processing and miniaturization of devices. Processing power is exponentially increasing all the time, so you're able to get a lot more smarts onto your devices early on. And artificial intelligence is one of those ones that is really sort of coming to the fore now. Mainly because it has a lot of core capabilities that are applicable to the medtech space, things like classifying. So if you're looking at images, as an example, is it a cat or is it a dog, or sort of more medical side, do you have a normal heart rhythm or have you got an irregular heartbeat? And AI can help one identify and classify that heart rhythm and then make decisions based on whether you're having any issues with your heartbeat and ECG. So if you have an implantable defibrillator device, it can automatically detect a arrhythmia and administer a shock to the heart to try and bring that back under control. Also, AI is very powerful in discovering new patterns in machine learning techniques. So if you have a patient who has some irregular heartbeat as their normal, the machine learning can detect that as a new normal and then use that as its baseline to identify deviations from that patient's new normal, which would really help to provide individualized treatment protocols for your patients using the devices. So how artificial intelligence works is primarily as a analogy to the human brain. So it has a series of nodes with a lot of hidden layers, which effectively are the neurons of the brain, and they are connected by these connections, which are all weighted. And so the artificial intelligence network takes a series of inputs, processes those through a series of weighted layers, a series of intermediate conclusions, again, a further set of weights and conclusions until you eventually get to an output. So what you might like to think about patenting if you've got an AI application is potentially your fundamental new algorithms and machine learning models, or you may look at the method of applying your AI techniques to a specific problem, such as echocardiography or speech recognition. You also might like to patent your new method of training your AI model. You may have come across a way of pre-processing your data, and that may give you some advantage in your training of your AI model, which then gives you an improved output. And you also may like to consider patenting your actual data sets or your processing of those data sets, or pre-processing to take raw data in, transform it into a form that is more amenable to machine learning algorithms. And of course, the trick with a lot of those things that you may like to patent is that not all of them are actually going to be patentable in all cases. So a couple tips for patents when you're in the MedTech space is you want to file early and often. So you want to be ensuring that you've got patent protection of your core technologies, and then file further patent applications for specific implementations of that technology. And you want to try, at least for your core technologies, to take a proactive approach to patenting your innovations, so you can take advantages of fast-track accelerated patent programs within the patent offices to secure that core IP protection early on, and then build on that with your application-specific patents. Patents attract finance, so your patent portfolio is often going to be the only way your investors have to place value on your company if you're in a situation where you're still going through your regulatory procedures. You don't actually have any sales or track record as yet. The only way that your investors can value your company is on the space of your patents. And it's also a very good idea to keep a track of your competitors' patents, because they can be very useful in identifying gaps in technology areas for your further research, where you might find a space that has fewer barriers to entry. There's not much research activity in a particular area, so you might like to move into that space. Also, patents are a great idea of forewarning of upcoming products by your competitors, because often the patent application will be filed 18 months or more before the new product comes on the market. So you have some form of forewarning as to what's going on in the space. So fundamentally, from a patent perspective, AI is a computer implemented algorithm or software. So, and there's obviously regulatory considerations of medical devices which utilize software. And as was mentioned, patenting of software can be difficult, but it's a bit of a myth that patents for software are not available. It's certainly not impossible, but it's country specific, and you have different rules in each country, and so what may or may not be patentable changes and is sort of often a very fluid situation because AI has increased so rapidly. The case law and the jurisprudence of the courts has not really caught up to the technology as yet, so it's very difficult to identify exactly where and when not is going to be a patentable invention. So in the US in general, they've been quite permissive of software patents in the past, but recently they've been moving towards an idea that non-abstract inventions are not patentable, and AI so often falls into that space of being a mere idea of applying certain technology to an application which falls under the abstract. So it can be difficult to get a patent in the US where you don't have a specific technical approach. And same in Europe, they have a much longer history with patents, and so they're much so they have much more well-developed rules around patents of software, what is patentable and not. And they take the approach of a technical solution to a technical problem. So a technical problem may include processing of images, driving a car, so there's a technical aspect to what the software is doing. Another technical problem would be technical process within the computer itself. So you may build a better computer for better power management, better memory management. And things that generally would not be classed as technical would be business or commerce-based innovations, such as plagiarism detection or categorizing documents in an office situation. So things that are tasks that a human historically has done in the past generally would not fall into the patentable realm. And in Australia, say 5 years ago, they were probably more aligned with the US approach, but in recent times they're becoming more closely aligned with the European. So the test for the Australian Patent Office uses at the moment is that they take an analysis of what the contribution of the invention is and whether that's technical in nature. So it does have that technical aspect wrapped into whether an idea is patentable or not. So, again, reasons that you might want to patent your AI-specific innovations. It's rapidly expanding. You're getting lots of new opportunities with the advancing technologies. Patents add value to your company. They attract investment. So just there's a quote there from a investor in medical companies in the US. That when evaluating whether to invest in a startup MedTech company, patents are critical. So it's a very, very good idea to keep a close eye on what IP you have and securing core patents for your core technologies. Patenting AI could be a potential marketing opportunity, so you could spruik to your audience your use of AI patents and AI technologies. Securing licensing deals, once you have a patent application on foot, it's very closely defined as to what you have as your core technologies. Otherwise, it can be quite, I guess, abstract. And is the term that when you're trying to describe your innovations to your potential investors, it can be quite difficult. Deterring competitors from copying your ideas. If you have patent protection around them, they have a barrier to entry that they need to be aware of, and build a defense against other patents. So if you have ever come across a situation where someone is threatening to sue for patent infringement of you, you might be able to counter-sue on your own, strength of your own patent applications, or you might be able to come to some cross-licensing agreement. So I license your patents and you license mine. So we can sort of have a bit of a closer look at what would not be patentable with AI. So the mere idea of applying machine learning to a particular problem without any new technical innovation. So if you don't have any technical aspect to your innovation, like retrieving data from sensors or applying or processing that data in a new way, or using the decisions that you come across from your models in a technical manner would not be patentable. And also, new fundamental mathematical models or techniques, so for example, a new algorithm implemented on conventional hardware, so it's a basic generic computer, would not be patentable, or any fundamental mathematical innovations. So things that would be generally applicable to a wide variety of applications, not likely to be patentable per se. So as a counterexample of what could be patentable, any of the above, which would be then tied to a particular machine or a method of doing a technical operation, that's going to be more likely to be patentable. So moving on from AI specifically, as it's very topical at the moment, a lot of companies would be looking to pivot their research focus in the current climate. There are a lot of IP factors that you really need to consider before you dive headfirst into your new focus area. So it can be separated into sort of internal and external factors. Internally, you want to be looking at your current intellectual property assets, your registered intellectual property, such as your patents, trademarks, any design registrations, but also any non-registered IP rights, like your trade secrets, know-how, copyright in your manuals or documentation, even key personnel. Their knowledge can be quite valuable intellectual property. And if possible, you want to try and identify any overlap between your existing IP for your current products and how to apply that into your new research focus. That will give you some core background technology that you can use to leverage off patent protection or further protections in the new research area. And then once you've just identified your new area, you want to file new applications early and often, and try and leverage your already protected core technologies into the new area. Some external factors when you're pivoting is you really need to be aware of the IP landscape in your new area. But simply copying existing products is going to be risky. So if you're going to start moving into mask production, you don't want to be automatically just picking a mask design that you like and start producing that. You're very likely to come afoul of some design rights that would be owned by others. So you want to try and identify whether any relevant patents or design IP already exists, and if necessary, try and obtain a license from the patent holder or design your own workaround that wouldn't be an infringement of the existing IP rights. Also, not just for patents, you want to be looking at possible trademarks or brand names in the new focus area for any products and services. So trademarks are usually issued for a specific product or service. So an example in this case would be Chanel repurposing their perfume production lines, so to produce hand sanitizer. If they're going to produce that under their Chanel brand, they need to be aware of whether there's any similar trademark registrations that would be relevant or registered in hand sanitizer areas. So another consideration that you need to be aware of is, do you actually own your IP? So when you're looking at patents, the inventor generally will own the IP. For designs, it would be the designer, the person that drew up the designs or the plans for the device. And copyright, the creator will own the IP. So your software developer or your technical manual copywriters. And unless, of course, that work, the invention, design, or the copyrighted work was made as part of the person's job, in which case, generally the employer will own the invention, and that will often be tied into your employment contracts. And of course, often the inventor or designer will assign the invention to their employer or to another party. Next slide. So when you're looking at collaboration, IP ownership becomes even more important because there's many parties involved. So you must carefully manage it between all your collaborators. So you want to be defining your ownership of existing intellectual property and background knowledge that's been brought into the collaboration from all your parties before you get started. And then when you're drawing up your collaboration agreements, you want to clearly define who's going to own the IP that's generated from that collaboration. A trick or a trap that you might need to be aware of is you need to be careful when you're signing your funding agreements. So will you actually own the IP that you create with that funding? In some cases, the funding organisation will make the money only available on the contingency that any intellectual property generated with those funds is assigned back to them. And when you're drawing up all these agreements, you want to be sure that they're all in writing and signed by all parties, so you're clear on the agreement before any new IP arises and you have any disputes down the track.
Thanks, Bill. I was just going to say as well, I forgot to say earlier, if any of our participants have any questions, please type them into the question box and we'll take a few minutes to answer as many as we can at the end of the presentation. So thanks for that. So what can you do to avoid disputes? Now, Phil has talked a little bit about ownership and assignments. That's certainly very much part of, I guess, one of the puzzle pieces for what you can do at the outset. The first thing is agreements. You know, you're going to be engaging with a lot of different stakeholders throughout the development, commercialisation and manufacturing process of MedTech inventions. And you want to make sure you've got proper, well-drafted, bespoke agreements with each of these parties that you're dealing with. There are a lot of template agreements that are around that look great when you pick them up, but the problem is they don't have enough detail which kind of specifically relates to the parties and the intentions that they have at the time of entering into the agreement. And it's only later on when there's a disagreement or an issue that's not contemplated by the template agreement that you start to realise that actually the thing that you downloaded off the internet wasn't so good. And it's worth spending the extra time and a bit of extra money on getting bespoke agreements that clearly set out what the obligations and rights are of each party. It helps, you know, crystallise exactly what it is that each party is expecting from the relationship at the outset, and also obviously avoids disputes arising later on if the rights and obligations are very clearly defined in those agreements. Following on from what Phil spoke about ownership, it's important to have the relevant assignments in place, both from your original inventors. You know, they might be your employees, but if they happen to develop their invention, you know, slightly outside of what their employment obligations were, you know, if they weren't employed in a R&D capacity, then you might well need to get an assignment. You might not automatically own the invention as the employer. So it's important to have all of those assignments in place. And the same goes for any collaborators that you have during the research and development process, any improvements that even your manufacturer might come up with. You know, at later stages, you should also make sure that the relevant assignments are in place to ensure that you are the owner of the IP. Those sorts of improvements can also be dealt with in the agreements that you have with manufacturers and so on as well. The other thing to have in place is non-disclosure agreements, particularly when you're discussing your technology at the outset with others. You need to make sure that these are in place, particularly before filing any patents or designs, to ensure that none of the information becomes public knowledge before you actually file your IP rights, because that can destroy the novelty of your IP rights. In addition, NDAs are a really important tool for ensuring that the parties know exactly what the information discussed during a meeting can actually be used for. Because the last thing you want is to, you know, divulge your great idea to somebody else to only have them adopt it and move on in their business without your consultation. So an NDA can delineate exactly what it is that a party can do with the information that they receive at such a meeting. In addition, to this all, we would also strongly recommend that everyone undertakes freedom to operate searching before, but Phil talked about it in the context of pivoting your technology or focus from one to another. But it's also really important in general when you're launching a new product or process in this space. From two perspectives. From the commercial perspective, it's to understand the competitor landscape, to know what other people in your field are doing. As patents are filed, often before a product is launched, it gives you an idea of what your competitor is looking to do, as well as Phil mentioned earlier on. But from the legal perspective, it ensures that what you're planning to do doesn't infringe third-party rights. So we would be looking at patent registers, design registers, and also from the trademarks perspective as well, to ensure that your brand or proposed brand doesn't infringe the rights of others that are already out there. And FTO searching also helps in terms of honing in on exactly where to focus and where the space is in the competitor landscape for you as well. So I understand that all of this sounds very expensive, particularly at the outset as a startup, as many of you may be. But the point is, you want to invest upfront to avoid disputes later on. Disputes tend to arise once your product or technology is in the profit generating phase. When your invention starts to generate real value, that's when the disagreements tend to arise. For example, on the allocation of profit or ownership. So you want to have all of these issues tied away well before that's an issue down the track, because it's a lot more expensive and much more of a headache to deal with these issues later on, once you've already launched your product or invested heavily in your product. So that's it from us. Phil, shall I hand it over to you to deal with the questions?
Yeah, so I guess if anyone has any questions about what we've gone through this afternoon, if you just type them into the Q&A box down the bottom, we'll try and answer as many as we can. There's only one at the moment. I think I'll just read that one out. So it's just probably for you, Bindhu. I've heard some upcoming regulatory changes for MedTech software coming into effect. Do you know what these are and when they do come into effect?
Yeah, so there are a few changes afoot at the moment. I think the starting date got pushed back a little bit due to COVID. But with respect to MedTech software, I believe that the starting date is February 2021. And then there's a transition period after that. Basically, the nature of that change is that software or medical technology in the software space will have to undergo classification under new classification rules. And basically, the classification is going to depend on the level of risk posed by the software. So if it's software that's used by a health professional or in conjunction with a health professional, that will generally be considered to be a low risk sort of piece of MedTech. Whereas if it's a sort of a monitoring software, then I think that's going to be considered, generally speaking, in the sort of medium range. However, if it's a piece of software that can provide a direct diagnosis or monitoring direct to the patient, and that's potentially higher risk. So I think, for example, apps that provide cognitive behavior therapy, that sort of thing, would be considered a little bit more high risk. But yes, that's certainly something to be aware of, and certainly something to get some advice on to make sure that you're ticking all the right boxes. Great.
Thanks, Bindhu. We don't seem to have any other questions at the moment. So if you've got any burning desire to know something that more about what we've touched on today, type your questions in. Otherwise, I guess I hope we've given you some sort of insight into some of the IP questions and sort of aspects that you need to be considering in your MedTech companies, with particularly identifying your core IP technologies and ensuring you have protections around those, and also in ensuring you've got ownership of what you create, and in your agreements with collaborators and your consultants, make sure that you've got those all tied away early, so in case you have any questions with. So sorry, Anthony's got a question. Let me just see if I can. All right, Anthony, if you want to go ahead and ask a question.
Yes, can you guys hear me?
Yes, we can. Thanks.
Firstly, thank you very much for a very informative presentation. I'm very grateful for the time that you've given. Question I have to both of you is that you talked about patenting early in your presentation here. And I was always under the impression that that was a good thing to do. Through a number of the bio innovation meetings that we've had locally in Perth, some of the impression that I've got from pharmaceutical companies is that they almost consider it a disadvantage if you patent early because the clock starts ticking on the patent. Can you speak to that in any way? I guess I'm left with a mixed message there, and I was hoping to get some clarification from you guys on that.
I guess I'll take that one. The reason you want to try and patent early is because you're right, the clock starts ticking, but your patent in your invention is always examined as of the date that you first file your application. So the earlier you get that date secured away in your own patent applications, then anything that happens after that is not relevant to the examination of your invention when it gets to the examination stage in the patent office. If you file too early, though, you've got to be careful that you don't have all the information that you might get out of your research efforts. And so what you would think about doing in that case is firstly trying to get a broad or generic patent application prepared around what you hope to do with as much information as possible, and then supplement that with further top-up patent applications when you have come across real useful data in your research. So I guess it's a bit of both. You want to try and secure the earliest priority date for your invention so that it helps go through the examination stage down the track, and you also want to try and trade that off with having as much information as you can or can develop at the time. So yes, we did. Yeah, the main reason for we say we recommend filing early is because of that priority date. Well, because once you start talking about your invention with others, then you may either preclude yourself from getting a patent for that innovation, or
seems like Phil's dropped out, but yeah, look, sorry, Phil, you just dropped out there.
No one. Oh, sorry. No, that's my connection's unstable. Sorry about that. Yeah, so I hope I got everything across to you, Anthony. If you've got any more questions, just let me know.
I will do. That was certainly helpful. I think, what I take from that is getting in a nice broad patent early and then following it up with some specifics as you do more research is really a good strategy. And that's something that I hadn't considered previously. So that's new insight for me. Thank you.
Yes, yeah, you're welcome. That's certainly what we try and promote wherever possible. You file a provisional patent application to the broadest aspect as possible, and then when you're doing your research in that year, you come across new ideas or improvements, and if those improvements have any particular merit in and of themselves, we recommend filing a new patent application to secure a new early priority date for that specific application or that improvement. So, yes. Got a question from David, and I'll just read it out. Do you see the scope of MedTech increasing with increasing technology applications, and does this increase widen or cross over into other IP space? I don't know, Bindhu, do you want to have a crack at that one?
I was going to leave that one with you, but yeah, I guess there is a little bit of bleed from one area to another with MedTech. MedTech doesn't have specific like delineations, but yeah, I think it does cross over into other areas of technology. Certainly, the engineering space, the software space, and certainly as more software is implemented within the MedTech space, that crossover is certainly increasing. I think the take-home message, though, is that the fundamental IP principles that apply are still the same, even if it does cross over into a different space. And so I guess most of the issues that we've talked about today will still equally apply. Phil, was there anything you wanted to add to that?
No, I was just going to say that yes, MedTech is one of these areas that does draw from a lot of background from different aspects and different technological areas like engineering, medical, innovations, biology, electronics. So there's a lot of areas that do get wrapped up into medical devices, and so can be quite rich in that sense that you have a lot of different ideas coming together, and that often has a lot of scope for new innovation.
Look, I think on that note, we'll wrap up here. Thank you very much for your time and for your questions. Of course, if you've got any other questions, our contact details are on the slides, which will be circulated. And please feel free to contact either one of us or both of us, and we'll do our best to answer your questions.
Great. Thank you very much, everybody.
Thanks.
Thank you.